All right, guys, Happy New Year's. And for New Year's, I actually have some good news to report to you guys, as common sense has prevailed in the judicial system as the U.S. Appeal Court upholds Florida's high school's transgender bathroom ban. Now, there has been a case going on in Florida about a high school who banned a transgender student from using the bathroom that does not match biological sex, and that student ended up suing. And this case right here has been going on, and the result is that the U.S. Appeals Court has basically said that the high school can, in fact, ban transgender students from using bathrooms that don't align with their biological sex. So, without further ado, let's actually play a news clip so you guys can get a better understanding of what's going on here.
Richard, thank you. A St. Johns County school is getting attention again as a years-long court battle on transgender rights has reached the national level.
So the fight centers on a lawsuit filed over whether the district should have prevented a Nice High School transgender male student from using the boys' bathroom. News4Jax reporter Aaron Farrar is joining us live this morning. Aaron, federal appeals court judges heard arguments and asked plenty of questions during a hearing yesterday.
News4Jax has been following this case for years now. It's between Nice High School and Drew Adams. And during that court hearing yesterday, the judges heard several arguments from both sides, and they said that it really focused on whether school board policy violates constitutional equal protection rights and Title IX. Drew Adams and his mother are still working through a lawsuit they filed against St. Johns County Schools in 2017. Adams was not allowed to use the boys' restroom while a student there because of the district's policy. Nice High School required Adams to use a gender-neutral, single-stall bathroom or a girls' restroom, saying Adams had to use the bathroom of the gender identified on enrollment documents at the time. An attorney representing Adams argued the rule was discrimination, saying in part, quote, Andrew Adams was treated differently because he was identified as one sex at birth and he identifies as male today, end quote. The school board says the restrictions were necessary to address students' privacy and safety concerns. An attorney for the school board said, quote, I would not concede the policy discriminates against any student. The policy had nothing to do with Mr. Adams' gender identity or any student's gender identity, end quote. And there's no word yet on when the panel will issue a ruling. It's being closely watched by now by several big corporations, as well as dozens of states and advocacy groups, because of the potential outcome that this can have. Reporting live, I'm Aaron Farrar, Channel 4, the local station.
Yeah, so you seen that, you heard that. This transgender student, okay, this woman that wants to be a man or a girl that wants to be a boy, sued the school because the school said, no, you can't use the boys' restroom. You're not allowed to use the boys' restroom. You got to use a gender-neutral bathroom, or you got to use the girl bathroom, the bathroom that aligns with your biological sex. And this student got upset about that and said, no, that's discrimination, right? You're discriminating against me because you're using common sense. That's essentially what this person is claiming. So without further ado, let's just go ahead and read a little bit more about what's going on here. A sharply divided federal appeals court on Friday upheld a Florida high school's policy forbidding transgender students from using bathrooms that accord with their chosen identities. In a 7-4 vote, the 11th U.S. Circuit Court of Appeals said the St. Johns County School Board did not violate the U.S. Constitution or federal civil rights law by requiring students to use bathrooms corresponding to their biological sex. The policy had been challenged by Drew Adams, a transgender man who sued in 2017 after being barred from using the boys' bathroom when he attended the Allen D. Nice High School in Ponte Vedra Beach, Florida. He had instead been required to use girls' or gender-neutral bathrooms. Guys, imagine suing, going through this whole process simply because the school's saying, look, you got to use the bathroom according to your biological sex. We have some gender-neutral bathrooms here for you if you want to use those. No, that's not good enough for this person. They got to sue for the right to be in a man's space, right? And vice versa, because they're actually really suing for all the other transgender students and people that want to do this as well. That's actually why they're actually suing, okay? But again, this is just ridiculous that this is even a thing. Quote, this is an apparent ruling that contradicts the rulings of every other circuit to consider the question across the country. Tara Borelli, a lawyer with Landa Legal representing Adams, said in a statement, quote, we will be reviewing and evaluating this dangerous decision over the weekend. This decision is dangerous. Yes, it is dangerous to not allow people of the opposite sex to use bathrooms that don't align with their genitalia. That's dangerous, but it's not dangerous the other way around to actually allow that, right? To allow boys and girls bathrooms. That's not dangerous, right? No student will take advantage of that policy and there won't be any bad things that happen, okay? Loudoun County doesn't exist, right? These people have never heard about what happened there. Apparently not, okay? But again, these people, it's just so funny how anytime you disagree with them, they say, well, it's dangerous. Your disagreement with me is dangerous. And they say that in order to stop all dissent, right? They don't want anybody to disagree with them. They don't want anybody to criticize them. So they just say, well, if you disagree with me, then you're dangerous. Lawyers for the school board did not immediately respond to requests for comment. All 7 judges in the Atlanta-based appeals court majority were appointed by Republican presidents, including 6 by Donald Trump, while the 4 dissenting judges were Democratic appointees. Yeah, I mean, no surprises that Democrats, they don't believe in common sense, right? They don't. 2 other federal appeals courts have ruled that transgender students can use bathrooms that accord with their identities. Friday's decision increases the likelihood that the U.S. Supreme Court will take up the issue. In June 2021, that court let stand one of the early appeal court's rulings in a case from Virginia. The Biden administration had urged the 11th Circuit to strike down the Florida school board's policy. The White House had no immediate comment. Adams contended that the high school's bathroom policy violated the Constitution's Equal Protection Clause and Title IX, which bars sex discrimination in education. Well, I don't see how this is sex discrimination because it's not like you don't have a bathroom available for you. You do have a bathroom available for you to use. It's either the gender neutral one or the one that aligns with your biological sex. I don't see where the discrimination is coming in here. Writing for the majority, Circuit Judge Barbara Legault disagreed, saying the school board had an important interest in protecting students' privacy and calling it wrong to suggest it relied on illegal stereotypes of transgender people. The Trump appointee also said Title IX allows separate bathrooms based on biological sex, citing the plain and ordinary meaning of sex in 1972 when that law took place. Well, ever since then, the left has tried to change the definition of sex as much as they can to basically be synonymous with their definition of gender, which basically means that, you can be anything that you want as long as you say or you think that that's what you are, then that's what you actually are. She also warned that ruling for Adams could transform schools, living facilities, locker rooms, showers, and sports teams into sex-neutral areas and activities. Whether Title IX should be amended to equate gender identity and transgender status with sex should be left to Congress, not the courts. Circuit Judge Jill Pryor, an appointee of Barack Obama, countered in dissent that by forcing Adams to use gender-neutral bathrooms, the St. John's School Board branded him with a badge of inferiority by deeming him unfit for equal protection. That, to me, sounds like a load of crap, right? How are you giving somebody a badge of inferiority by simply saying, look, you got to use the bathrooms that align with your biological sex or that are gender-neutral? If anything, if you just allow this person to use whatever bathroom they want, you're actually giving them a badge of superiority over other students because you don't care about how those girls, the biological girls or biological boys, are feeling when they have somebody in the bathroom that is of the opposite sex. You don't care about how uncomfortable they are, right? So, I really don't understand this coming from these Democrat judges. But again, these people are Looney Tunes, so it's not a surprise that, the things they say don't really make sense. The Constitution and the laws of the United States promise that no person will have to wear such a badge because of an immutable characteristic. Pryor wrote, the majority opinion breaks that promise. U.S. states are also divided on transgender bathrooms. 22 largely Democrat-leaning states and Washington, D.C. supported Adams, and 18 largely Republican-leaning states supported the school board in legal briefs, court records show. A divided 3-judge panel of the 11th Circuit had previously struck down the boys' bathroom policy as unconstitutional. Friday's decision reversed that ruling. Yeah, so this most likely is going to go to the Supreme Court. And we will see, right, how the conservative court rules. If I was a betting man, then I would hope that they would uphold common sense and not force biological girls and biological boys to have to use the bathroom with people of the opposite sex, right? I would hope that a conservative Supreme Court would, at the very least, do the right thing here, okay? Because if they can't get this one right, then there's a problem, right? There's a big problem with the conservative court if they can't get this one right. So let me know what you guys think. Make sure you like, comment, and subscribe. Most importantly, share a Black conservative perspective. Peace.